Good morning, everyone, and thank you all for coming. I'm Namita Wahi. I'm a fellow at the Center for Policy Research, and on behalf of the Center and our president, Dr. Pratap Bhanu Mehta, I'd like to welcome all of you to this seminar on understanding land acquisition disputes in India. Um, Today, we are going to present our findings from a year-long study of all reported Supreme Court decisions on land acquisition decided over the period 1950 to 2015. 1950 was when the Supreme Court came into existence, so that's the starting point, and the end point is December 2015. The team who worked on this study included, on my left, Pallav Shukla, and on my right, Ankit Bhatia, Research Associates at the Land Rights Initiative, and also on my left, Dhruva Gandhi and Shubham Jain, our interns from National Law School, Bangalore. I also want to take this opportunity to thank the Asia Foundation and Mandakini Suri for all the support that has made this work possible, and also everyone at the Center for Policy Research, including our interns outside who have helped to put this event together. The goal of this project was essentially to develop a better understanding of conflicts and disputes relating to land acquisition by the state, and to do so by building systematic knowledge on the subset of legal disputes that have been litigated before the Supreme Court of India. The plan for today is as follows. I will speak briefly about the trajectory of the law on land acquisition. Then Ankit and I will speak about the research methodology we used for our study. And finally, Pallav and I will talk about our research findings. So it's about 10 minutes to 10 right now. We will speak for about an hour and a half, and because this is being video recorded, we would request you to keep your questions until the end, and we'll have then an hour for discussion. And after that, you're all welcome to join us for lunch in the adjoining terrace pergola. So now we are all familiar with the controversy on land acquisition. But to quickly sum up the historical trajectory of the law on land acquisition and the contentious issues so that we are all on the same page, the British colonial state enacted a number of laws, the most important of which was the Land Acquisition Act of 1894, to facilitate the state's takeover of land pursuant to its power of eminent domain, upon a showing of public purpose and upon payment of compensation. When the Constitution was adopted in 1950, within India's federal constitutional system, land was included as a subject in the state list. But the acquisition and requisitioning of property was included as a subject in the concurrent list, which meant that while only state legislatures could make laws on land, both central and state legislatures were empowered to enact laws on land acquisition. At the time of independence, several states, the princely states, had their own laws of land acquisition, which coexisted along with the 1894 Act until the 1894 Act was made applicable to all of India. So earlier it was applicable only to the territories of British India, but once the princely states were consolidated, it was made applicable to all of India. At this point, over the course of the last 65 years, several states also amended the 1894 Act. Therefore, we had a situation, both at the time of independence and even today, where we have numerous central and state laws of land acquisition. Nevertheless, the 1894 Act was and remains the most important law, or remained the most important law, for a period of 119 years, until it was repealed and replaced by the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act of 2013, which is quite a mouthful, so I'm going to call it the LARR Act of 2013. Now, this act was enacted in September 2013, but came into force upon its notification in the Official Gazette on January the 1st, 2014. The Act came into force after more than a decade of efforts to first amend and later to repeal and replace the 1894 Act, following widespread public outrage against the manner of implementation of the 1894 Act by the state administration. This Act made changes to 5 provisions that had been found to be contentious in the 1894 Act. What were these provisions? The first the first contentious issue with the 1894 Act was that it only recognized the claims of title holders, but not of livelihood losers or people who had other kinds of interest in the land, like easement or tenancy interests. Second, it only had an inclusive definition of public purpose, and it was believed that over time this definition of public purpose was used to acquire land for purposes that were considered not public or not legitimate. Third, it provided for payment of less than market value compensation, or it was at least administered to result in payment of less than market value. Fourth, there were procedural delays, and it was also believed that the procedure did not allow the public any participation in the decision by the state to acquire the land. And finally, there was misuse of the urgency clause. The urgency clause essentially allowed the state to bypass the procedure prescribed under the Act in situations of urgency. But the provision, it was believed, was not used just in situations of urgency, it was used all the time. The 2013 LARR Act made the following changes to each of these 5 contentious provisions. First, it broadened the group of land claimants and people who needed to be consulted to include not just title holders, but all those who had an interest in the land, including tenancy and easement rights, and those dependent upon the land for their primary source of livelihood. On public purpose, the 2013 Act provided a much more detailed listing of public purposes with a view to restrict the definition of public purpose, but it was a very long list. On compensation, the 1894 Act had provided for compensation according to the market value of the land and payment of a solatium. Solatium is Latin for solace, a solace amount on top of that, which was approximately 30% of the market value. The LARR Act increased the solatium to 100% and provided a formula whereby the compensation to be paid was to be twice the value of the average of registered sale deeds in urban areas and 4 times that value in rural areas. It also provided for rehabilitation and resettlement awards. These awards included, for instance, the provision of a constructed house in place of the house lost through acquisition of land. It also provided in certain cases, but not all, for the grant of land in place of land acquired. Next, in terms of procedure for land acquisition, the Act introduced provisions for consent of persons interested before acquisition could take place, so 70% for government acquisitions and 80% for public-private partnerships, and also detailed provisions for social impact assessment of projects before land was to be acquired, which sought to ensure greater public participation in acquisition proceedings. And finally, it limited the invocation of the urgency clause to situations involving India's defense, national security, or for emergencies due to natural calamities. Can you go back to the slide before? Yeah, before. Previous slide. Now, on December 31st, 2014, a year after the 2013 law had been in force, the Union government notified the LARR Ordinance of 2014. Now, this ordinance substantially altered the provisions in the 2013 Act by exempting a large number of infrastructure and other projects from the consent and SIA provisions of the 2013 Act. The ordinance was repromulgated twice, and in June 2015, a bill to replace the ordinance was referred to a joint parliamentary committee. On March 16, 2016, the Joint Parliamentary Committee was given a 6th extension to submit its report, but it is pretty clear that the government has abandoned its attempt to pass this as a law due to lack of parliamentary support. And the government's inability to do so testifies to the intense and continued political contestation regarding this subject, and underscores the salience of what we are discussing today. The Niti Aayog, the body which has replaced the Planning Commission, took the position that in the absence of parliamentary consensus, state governments should go ahead with their own amendments to the 2013 law, which they are empowered to do so. Now, several states, including Tamil Nadu, which amended the law in 2015, and Gujarat, which amended it only in April of this year, have derogated from the provisions of the 2013 law. Other states that are considering such amendments include Karnataka, Rajasthan, Maharashtra, Assam, Andhra Pradesh, and Madhya Pradesh. So, we are again in a situation where essentially what we might see as time goes on, that we have again a multiplicity of laws that will be regulating land acquisition in different parts of the country. So in some ways, the Law Commission of India, which was tasked in 1958 to prepare a report on land acquisition, had lamented the fact that we have so many different kinds of laws, and it had recommended to the government that we should actually try to move towards uniformity of the law. 50 years down the line, we had the 2013 law, and I'm going to speak about what I think were positive features of that law and what were not so positive features. But the point is, there was an attempt to bring about uniformity, but that has obviously not sustained, and what we are going to see is increasing heterogeneity. So that's where we find ourselves. Now, against this backdrop, we're now going to speak about the research design methodology we used for this project. Now, from all that I've said thus far, it is clear that land acquisition is one of the most contentious issues in India, and the history of legislative efforts on this subject shows that we haven't resolved this, and it won't be resolved for a long time. Because India is a land-scarce country, and the current hegemonic model of economic development is both land and resource intensive, land acquisition will be a necessary evil. So if we are going to have land acquisition, what we can do is to think about ways of making the process more equitable and efficient. And we hope that our study will help inform the discourse about the scope and limits of legal change in achieving this goal. Our study is also important, we believe, because while there has been much written on land acquisition, there have only been a few systematic studies to the best of our knowledge. These existing studies, which are listed on the project over there, can be divided into two types. The first is a study which has mapped the extent of conflict. So, for instance, the Rights and Resources Initiative, a Washington-based think tank, did a mapping of land acquisition-related conflicts in 2013 and 2014, which showed that a quarter of all of India's districts have ongoing political and legal conflicts over land, and that this conflict was growing. It also showed that the highest number of conflicts during this period were with respect to coal mining and irrigation. The study was important insofar as it highlighted the extent of the conflict over land, but it didn't really shed much light on how such conflict might be averted. The second set of studies, mostly by economists and people in the government, have focused on one of the 5 contentious issues that I have described, that of compensation. The study by Ram Singh, an economist at the Delhi School of Economics, Professor Ram Singh, who studied additional district court judgments in Delhi and Punjab and Haryana High Courts over a 3-year period, again from 2008 to 2010. Based on his study, he concluded that in a vast majority of cases in both courts, awards of compensation were increased, and the average increases were by 200%. The second study is a book by Professor Sanjoy Chakravarti from Temple University called The Price of Land, which evaluated land markets in India. Now, both these studies did talk about other issues, but really the extent of their primary work and the conclusions they derived were on the question of compensation. And this study described how the compensation provisions under the new Act, the 2013 Act, which increased compensation to 4 times of the average of registered sale deeds in rural areas and twice in urban areas, would affect the land markets under this law and make land acquisition for the purposes of economic development too expensive. That was the conclusion, that this was unsustainable. Again, this study looked at rural and urban land market data, but for selected regions. And finally, a study by Mr. T.V. Somanathan, a senior bureaucrat currently in the Prime Minister's office, who looked at land acquisition for the Chennai Metro Rail project and argued that courts were likely to award 4 times the compensation typically awarded by the government, so that what the LARR Act was going to do was not going to be that revolutionary in terms of the increases in compensation. So these are the existing studies. They were all instructive, but were limited in time and geographical scope, and also focused, as I said, on only one of the 5 contentious issues, that of compensation. Now, since the Supreme Court hears cases from all high courts in the country, and because we have looked at all 5 contentious issues with the law, the database of cases that forms this study is representative both in terms of geographical scope as well as the nature of the legal issues being litigated. Moreover, it is also comprehensive in terms of the time period covered, because we've done everything. We've covered the entire 65-year period. So, to the best of our knowledge, such a comprehensive and representative study has not been done before, and I think that's why this work is important. So, how did we go about doing this study? The creation of the systematic knowledge base involved the following steps. The first was collection of all the relevant Supreme Court cases on land acquisition. Now, here we relied primarily on two Supreme Court online archives, Manupatra and SEC Online. We used Manupatra as the primary database and used SEC Online as a secondary database to verify our results, thus to make sure that we had caught all the cases on land acquisition. In the process, we collected a database of 2,520 cases from Manupatra and an additional 546 cases from SEC Online. So the total database of cases we collected was 3,066. Based on existing knowledge on land acquisition, we devised a preliminary questionnaire along the following three lines of inquiry. Next slide. First was the procedural and jurisdictional aspects of these cases. We wanted to understand who were the claimants that were bringing these claims to court, and how was the court actually exercising jurisdiction or hearing these cases, both the High Court and the Supreme Court. And then how was the Supreme Court's procedural treatment of the case, and finally, how long did it actually take for a case to be decided by the Supreme Court? Next, we looked into the substantive aspects, the substantive legal issues. Now, if you'll recall, I said there were 5 issues, and here there are 4. Basically, we wanted to see, have parties contested, and how have the High Court and the Supreme Court decided questions of public purpose, compensation, procedure, and urgency. The 5th thing was about recognition of livelihood losers and not title holders. Now, obviously, that's a new development in the 2013 law, so none of these cases would have anything on that. In fact, we don't know how that is going to play out in the future, because whatever cases we've looked at in the last 2 years since the law came into force haven't really seen claims of that kind, but they're sure to come, and we'll have to see how that goes. And finally, we tried to do a distributional analysis in terms of both the time and the decadal analysis of the cases, as well as a geographical distribution. Where are the cases coming from? State-wise, what are the kinds of, which are the states which have maximum number of cases? What are the purposes for which land is being acquired? And what are the laws that are being implicated in this litigation? You can go back. The next stage was to conduct interviews with experts in various states, including activists, government officials, academics. Following all these discussions, we developed the questionnaire, and we decided to follow an empirical approach with limited coded responses, yes or no, or specific responses to specific questions. We then conducted a sample review of the cases in order to assess the strengths and weaknesses of the preliminary questionnaire. And Ankit is going to speak more about the sampling methods. I'm just going to run through some of the other stages and then hand it over to Ankit to speak in more detail about sampling and the consolidation of the database. But essentially, after we did a sample of 6.5% of the cases, about 200 cases, we then finalized the questionnaire. And then we did a systematic review of all cases and creation of the data set. Basically, the team here did all of that. And then we consolidated the database, cross-verified the cases, made revisions in the data set based on cross-verification, and finally created a graphical representation of the data. So I'll now hand over to Ankit to discuss some of these in more detail.
Hello everyone, good morning. So now I'm going to focus more about the actual statistical strategy that we implemented to review these cases and produce the analytical results in the end. So first of all was like the sample testing that we did. So initially when we had our first questionnaire, which was based on our preliminary understanding, then we did a sample review of the 10% of the cases, and this was done in two times. So we created a sample of 10% of the cases based on the distribution that we had over the time period. That is how the cases are distributed over the time from 1950 to 2015. As we will show in the preceding slides, there's a lot of variation between the years over which we have received different kind of judgments. So based on this, a sample was created, and we rerun the entire exercise to see if our questionnaire that we developed was giving the answers that we were looking for. And based on these corrections, we corrected our questionnaire and reached to the final questionnaire that we had. Once we had the final questionnaire and based on the cases that we were reviewing, so the next exercise was about the consolidation of the database. And like we had around 5 people who were working with us and from different geographical locations, and they were sending the data. And so I was trying to consolidate the data, and it involves some of the important steps. Like first of all was the data cleaning. Although like most of our questionnaire was very objective in nature, we tried to be as objective as possible. But even though, like, to maintain the there was also subjective element to the responses which we could not ignore entirely. So the subjective responses were to be cited in a way that we don't miss out the relative information, but in the end we are able to produce some analytical understanding from this database. And second, in terms of data cleaning, was the human error. Rather than despite being very precise about the manner in which the codes has to be filled, but there were still some human errors which has to be removed before the data could be processed and the results could be produced. Next thing after data cleaning was data standardization process. So in data standardization, basically, like in some of the codes which we did not anticipate, there were some responses, they were in that format, and we tried to put those responses in a standard format so that there's a consistency across the entire database. And then there was multiple format in which the respondents were filing the responses. We tried to standardize them, and there were multiple revisions over the time in terms of, like, we added, like, from the Manupatra cases, then we moved on to Supreme SSC online cases. So these were some of the processes that we followed. But once this data was ready, then we moved on to the data analysis part, that is analyzing the data and producing the trends that we will be presenting shortly. So basically there are three kind of analysis that we did in this. So one is the aggregate analysis. Aggregate analysis shows us the trend over the entire database of 1369 cases. But that was just like an average understanding of how the trends are moving. In the next step, we divided the database into two processes. One was the decade-wise analysis. That is, we divided the entire database into 7 different decades. That is 1950 to 60, 60 to 70, and so on. And try to see how these trends are produced, and what is the variation within the different decades over the variables that we have selected. And next was the state-wise analysis. State over here is a proxy for the high courts, that we are seeing that how the cases were coming from the different high courts and what is the variation between them across different variables. And after this analysis, like, we produce the results in the graphical representation, which we'll be discussing from now on. And we'll be producing some of the analysis over here, the aggregate analysis and decade-wise analysis primarily. State-wise analysis is not presented because of the paucity of the time that we have right now, but that part is also completed. Now I want to hand it over to Pallav for the next round to discuss this.
Yeah. So once we uh, once we consolidated the database, we basically were left with 1,369 cases. The rest were excluded for the following reasons: either because they had nothing to do with acquisition, or were land reform cases which did not involve a contest to the land acquisition provisions. So, in other words, we do have some land reform cases in our database, but only those which involved a contest to land acquisition. If there were other challenges like constitutionality or repugnancy or whatever, those were not included. Or if they related to deprivation of property rights not related to land, especially with respect to employment matters and so on, again they were excluded from the database. So the final database consisted of 1369 cases which squarely involved a challenge to the land acquisition law. On the one hand, that's the meta challenge to the law itself, or to acquisitions made under that law on one of the four grounds that we mentioned in the substantive aspects. So now we'll go into the findings, and so I'll hand over to Pallav to speak about the procedural and jurisdictional aspects of the cases.
Hi, good morning. So, before I begin, just because there may not all be lawyers over here, um, there are typically 4 provisions under the Indian Constitution that allow a citizen or a non-citizen to bring cases to the constitutional courts, the High Court and the Supreme Court. The others are typically like lawsuits between the people who are actually affected and people who are the defendants. But I'll move to Article 32, which comes in through the slides. Article 32 is a provision which allows any person, any individual, or a group to move the Supreme Court directly without going through any of the courts in the hierarchy of courts in India. This is typically done only when there is a challenge to the state impinging on a citizen or a non citizen's fundamental right. So whenever there's a fundamental right challenge, you can directly move the Supreme Court under Article 32. The other provision that is typically used to approach the Supreme Court is the SLP. It's in Article 136 of the Constitution, which basically provides that anyone who's aggrieved by can approach the Supreme Court by manner of special appeal. So you may be in the district court. You do not want to go through the whole hierarchy of courts, and you can use Article 136. If you can make out a case, the Supreme Court will allow a special appeal directly to the Supreme Court. How the high courts typically function is Article 32 has more or less corresponding provision called Article 226, which is a protection where the high courts protect not just the fundamental rights but any other rights. It's a broader power of the high courts, and we'll come to the next slide where we'll see Article 226 in play. Essentially, the idea is that Article 32, which is a direct approach to the Supreme Court, Article 136, which is a manner where you can appeal to the Supreme Court directly without going through any of the hierarchy of courts, and Article 226, they've played a really important role in how citizens have litigated land issues in the constitutional courts. Now, the slide that we're seeing here is the manner of appeal to the Supreme Court. When we are looking at Supreme Court cases, we were analyzing all of these judgments. One of the first things that the court typically talks about is the procedural history of how matters came to the Supreme Court. And we've seen from our database that almost about 59% of cases were through the SLP, which, like I said, is a special leave to appeal to the Supreme Court. And the court has been pretty generous in allowing litigants to directly approach the Supreme Court and litigate issues in appeal at the apex court. The second highest is the civil appeal. A civil appeal is typically when the land acquisition law provides that a case can be taken up all the way to the Supreme Court. So the statute will provide that there is a mechanism where you can go from court A to court B and finally to the Supreme Court. And that is the second highest number of cases, which is not, we are not surprised because that if the law provides you an opportunity, why not take it? But SLP was, it's not surprising to us lawyers so much, but for a layman that matters are being litigated directly at the apex court with such high frequency. Article 32, which was a direct challenge to the impinging on the fundamental rights by the state, was the third highest, but there's a marginal difference. And Article 32 was where citizens were directly saying that, hey, my right to X or right to Y, which is a fundamental right, is being taken away by the state through this land acquisition. And that is the third highest challenge. The remaining, while not so much, are interesting because the court is taking up two separate kinds of challenges which involve the same subject, like an SLP or a civil appeal, because maybe the land which is under dispute may be the same, or the people had similar interests. The court is clubbing all of these separate remedies and taking them together. So relatively fewer, but nonetheless we did find instances where the court was clubbing issues and clubbing various different remedies and taking them together. Could have the next one. So the blue line that you see, which is increase over the years and significant, is the SLP that I was talking about. The red and the yellow become insignificant because they are Article 32, which is a fundamental right challenge, not so strongly taken up by the court. Although, if you look at the earlier decades, until the 1970s, the red line still has some significance because it is until then that right to property was a fundamental right under the Constitution. You would find people making Article 32 challenges directly to the Supreme Court saying that my right to property is being taken away by the land acquisition and therefore I have a right to approach the Supreme Court directly. But increasingly, the SLPs became more important, the courts became more indulgent, and but there is some sort of a mirror image that comes across between civil appeal, which is the green line, and the blue line, which is the SLP. That's not necessarily a choice being made by the litigants, but SLP being preferred as against a civil appeal, typically. by litigants so as to approach the Supreme Court as quickly as possible right early in the litigation so that you could get some sort of an advantage by, presumably by going to the court right away. Yeah. So, from a reading of the judgments of the Supreme Court, we could also find out some of the background in the matter, where all this information is coming typically from how the Supreme Court reports the procedural history in some of these cases. And like I said, Article 226 figures very strongly in most of these procedural in the procedure, in the manner in which cases came to the Supreme Court, where people took up challenges directly before the High Court, whether it was a notification, whether it was a public purpose challenge, or whether there was a procedural irregularity. All of that it comes within the broad powers of the High Courts under Article 226 of the Constitution. The courts can protect not just any violation of a fundamental right, but also any due process challenges that can be brought by a citizen during the process of land acquisition. So again, not surprising, Article 226 is the maximum number of cases that litigants use to approach the first constitutional court, which is the High Courts. The second, obviously, is the statutory appeals, which I said is similar to civil appeals in the last slide, where and the statute itself provides a provision for a litigant to approach the next higher court, which is the High Court in these cases. And the third, which is marginal, is because the court is trying to mix an Article 226 challenge along with a statutory appeal and taking up cases together, while not so much as compared to statutory and Article 226. The third is information not available, because we're looking only at the Supreme Court sample, and when the Supreme Court actually writes down or narrates the procedural history is how we came to know how cases were taken up in the lower courts, including the High Court. So there was roughly about 8% cases where the Supreme Court did not record in its judgment how cases were being litigated and what was the procedural history in these cases being brought to the Supreme Court. And this is a similar graph to the Supreme Court, where we'll see that the 226 challenge, which is the blue line moving on the graph, became increasingly important, where the High Courts became more indulgent in the Article 226 petitions, and allowed more and more litigants to sort of bring in the writ petitions, as we call them, before the High Courts in order to challenge some of the procedural irregularities and other due process issues right to the High Court in the first instance. This slide basically speaks, we were trying to understand whether courts are looking, whether individuals are approaching the courts, or whether it is a bunch of people are litigating the matters to the Supreme Court or the High Courts. And this is for the Supreme Court, where we saw that bunch petition is essentially the court says that, okay, XYZ cases before me are by different individuals, but they have a common thread of thought, or there is a common issue to be decided between these people, or there's a common piece of land. These could all be different cases, but let me decide them together. So we saw that roughly equal number of cases where there were cases being bunched together by the court and decided together, and cases where people were individually litigating their rights and issues before the Supreme Court. We also looked at whether it is single or individuals who are bringing cases, or whether it is a number of people coming together and bringing cases to the Supreme Court. Now, and we clearly saw that people saw an advantage in bringing their cases and causes together and filing cases as a single block of plaintiff before the Supreme Court. And clearly 71% almost were multiple parties litigating a matter where where people thought it was advantageous to bunch their resources and to bring their resources together and then litigate, rather than individual litigating his own personal right. And this is not surprising in land issues, because land acquisition matters typically involve large pieces of land and a lot of landowners, and they would see advantage in coming together and engaging a counsel and having a common brief and then approaching the Supreme Court. We also analyzed whether the government was bringing more actions to the Supreme Court, or whether it was the private individual who's bringing more actions to the Supreme Court. And clearly, we saw that 61%, or almost 61% of cases being brought to the Supreme Court in land acquisition cases were being brought by private parties and not by the government. So the majority of cases being brought are by the private individuals. That may not necessarily mean that the private individual has lost in the lower forum. It could, like for example, in compensation cases, you may have got an increase in your compensation even at the High Court, but you still think that there is a good chance I'll have more compensation be awarded by the Supreme Court, and I become a litigant again before the Supreme Court. So, private parties bringing more cases to the Supreme Court than the government. And the converse, where since this is basically a mirror image of the previous slide, where the government is increasingly a respondent in the Supreme Court, at least for land acquisition issues, than private parties. We also thought it would be interesting to look at how many judges are actually sitting on these cases together while deciding. As you understand, 31 judges of the Supreme Court, not all of them sit together, unlike in the United States. They sit in benches. So benches used to be much bigger when the court had just started out in the 1950s. Typically, judges would be sitting together much more often and deciding cases. But as the case load increased and as the number of judges increased, obviously the courtrooms remain of the same size. So they started sitting in benches and getting more specialized and taking up matters based on subject areas rather than sitting together and deliberating on every matter by every judge. So presently, except for the Chief Justice's court, all judges sit in twos. And this is what we've seen. And this has been a practice which has been going on for some time. And almost about 77% of cases have been decided by two judges of the Supreme Court sitting together. There are times when there are three. And about 7% were decided by five, and just under 1% by more than five judges. So typically, you will, in today's times, you will find five judges sitting together only when there is a constitutional question be decided where two judges disagree, where the Chief Justice actually constitutes a special bench and judges are actually pondering over a question of law, not so much deciding a dispute between the parties, but essentially settling the law, essentially looking at constitutional questions. And those are a fairly small number compared to the daily cases where about 77%, where judges are simply just adjudicating cases between parties, just saying this is right, this is wrong, you're getting more compensation, you're losing out, and that sort of procedural adjudication on a day-to-day basis. The average time period is when we're looking at three steps in the life of let's say a lawsuit relating to land acquisition. The first is when the notification is issued. That's the first benchmark. This is point A, where the notification is issued informing the public that your land is being taken away by the state. The second landmark that we looked at, which is point B, was the date when the High Court issued its judgment. The third point, which is point C, is when the Supreme Court issued its judgment. Now, this may be a fairly simplistic way of looking at things, and there's a much more detailed analysis can be done with this data. But we, for our convenience, looked at notification as point A, High Court judgment as point B, and Supreme Court judgment as point C. And we tried to see what is the average time period. Now, this is all in months, and on an average, from the date the notification is issued telling the people that their land is being acquired to the date the High Court issued a judgment is about 155 months. Relatively smaller is about 78 months when there's a time period between the High Court issues its judgment and the Supreme Court comes out with its own judgment on the appeal from the High Court. And significantly high, of course, is the time lag between the time difference between when the notification was issued and the Supreme Court came out with its judgment on that issue. So 223 months. It's a really long time.
For 19 years, if I can just come in here, I think that this is really important to keep in mind as we speak about the rest of our data, because if it takes about 14 years, 14 and a half years for a case to be decided by the High Court, and then it takes about 19 years for the case to be decided by the Supreme Court, then and remember, our data is about decided cases. So cases that are being decided today may have originated a long time ago. Now, this doesn't mean that this is a time period of pendency, because a lot of the times what we'll find is that parties, their land may have been notified for acquisition, but they may actually not approach the court until like 8 years down the line, just because the notification procedures have not been completed, land has not been taken possession of. It's only when that happens that they do go to court. So while the High Court and Supreme Court time period does give a time period of pendency, but not necessarily the notification to High Court period.
Yeah. I'm sorry.
Yeah. We'll answer that, but we're taking questions at the end because it's being video recorded.
So minimum is like around half and half year to like it ranges to around 86 years. There is something like that. It's huge. The variation is huge.
Yes, and this is a graphical representation of the bar chart that we saw, and clearly, the trend is only increasing as the workload before the courts increased. So did the time period in deciding these cases, and the orange line, the red or the orange line that you see is the time difference between notification and the Supreme Court judgment being issued. The blue line is the time difference between the notification and the High Court judgment being issued. We've seen a slight dip in the green line where there was a massive time difference, relatively larger time difference between the 1970s and the 1990s, where which is the time difference between the High Court judgment and the Supreme Court judgment. But that figure seems to be declining. It could be for various reasons, including computerization, hiring of more judges, and various other factors, where the time difference between the High Court judgment and the Supreme Court judgment has actually seen a slight decline, but there's a clear upward trend when it comes to the time differences between the notification and the judgments issued by the High Court and the Supreme Court. So that's the jurisdictional and other aspects of the analysis. But I'll hand over the mic to Namita for discussing the most substantive findings on what we found from really analyzing most of these issues. Thank you.
Thank you, Pallav. So, if the first issue, which is that of public purpose, the findings on public purpose were not altogether astonishing. Based on the existing knowledge and the work that I've done on land acquisition, I'd actually expected to see very little challenge to public purpose, and we find that only 7.16% of the cases did involve a challenge. And in fact, if we look at the decadal analysis of this, we find that the majority of these challenges actually happened during the 1950s. And during the 1950s, one of the interesting features which sort of comes up in all of the analysis is that there were a number of land reform laws that were passed, and there were a lot of challenges both to constitutionality and to public purpose under that law. Also, during the 50s, the court, once it basically, as we see, there has been a steady decline in challenges since the 50s, because in the 50s, the Supreme Court adopted a very deferential stance towards assessments of public purpose, essentially saying that in a continuously evolving economy and polity, anything the government deemed fit to be a public purpose would be a public purpose. So there would be scrutiny, but it would be very, very deferential. And once the Supreme Court signals something that they're not going to look into it in a certain way, it is unlikely that challenges will be brought. It's in many ways we see that where once it might take some time for the for the high courts and so on to follow suit, but eventually they would. But I think that this finding also comes from the fact that the real problem in the functioning of the Land Acquisition Act does not stem from the purposes for which land was acquired, because they do seem fairly legitimate. And that's why, when we are talking about amendments to the law, often certain things assume a disproportionate stance. So there might have been a few acquisitions recently for purposes that were considered illegitimate, various housing scams and so on. And then suddenly there's this widespread need perceived that we need to alter public purpose because actually everything is being acquired not for public purpose. That's not really the case if we look at the cases over the years. So The next graph. If you look at how the Supreme Court decided, the court essentially upheld public purpose in over 85% of the cases. And if we look at the cases, the small number of cases where public purpose was invalidated, so this is about 14.6% of 7% of the cases, so a very small number of cases, we find that they are as much about violations in the procedure for acquisition as they are about public purpose. And some of them are just complete government apathy in their showing of public purpose before the court. Some have a distinct scam feeling about them, and so there are cases like that, but they are more about the procedure that was followed and therefore the public purpose. And we also have a couple of judgments where the court is admonishing the relevant government officials for lying in their affidavits before the court or not producing or not having the appropriate records. If we look at so decadally as well, the challenges have been very few, and the court has been very consistent pretty much, except recently. But then the challenges in that decade have also been very low, so the numbers are not that significant. Now, if you look at the purpose-wise distribution of cases, we found that unfortunately in almost, there's the number there which the largest number of acquisitions are obviously for the purposes of planned development, which is about over 21% of the cases. Planned development usually refers to those kinds of acquisition where the land has been taken for the construction of a complex with both residential and commercial aspects, or where the government wants to improve the overall infrastructure in the area. So an example would be a residential colony with a shopping arcade and a commercial hub, or a residential colony with a market area, roads, and other basic amenities. The statutes under which land has been acquired for these purposes are mostly the 1894 Act, but also a number of state town planning acts. Acquisition for industry, whether it is an industrial park or an industrial corridor or a standalone factory. So they were all grouped together under one head. So acquisition for industry is the next big category, so about 11% of the cases. Affordable housing for the poor and for the weaker sections of society, especially the scheduled castes, is also an equally contentious issue, with almost 6.5% of the case, 9.5% of the cases are for affordable housing, then followed by defense and agrarian land reform. Interestingly, considering the RRI study, which showed that dams and mining is a huge source of conflict, we actually find that the cases before the court is only 3% for dams and about 2% for mining. But that is the case because, as you would recall, the 1894 Act and other acquisition laws only protect the interests of title holders. And a lot of dams and mining work is carried out in areas where there aren't individual titles to the land, and the people who are being displaced because of these acquisitions, a lot of these are in the scheduled areas, others are in forest areas where until the Forest Rights Act, people had no rights. So this data does not show, that these are not, the data does not show that these are the purposes, the largest purposes for which land is being acquired. No, these are the largest purposes for which land acquisition is being litigated. And then it makes sense because planned development is only happening in the cities, and people who have both the title to the land as well as the ability to bring these claims are more likely to be urban residents. So that explains the planned development category and also industry. Defense is also a pretty big category. And then there are a variety of other reasons for which land has been acquired. And, like resettlement of refugees was a big thing again in the 50s decade. And railways, forests, hospitals. All of these, again, they are all categories for which there are different laws. The railways has a number of land acquisition provisions. Again, metro construction, something new, slum clearance and development, ports. And very interestingly, there wasn't any cases on special economic zones. Now, of course, as we have shown that the average life of the case is quite long, and the Special Economic Zones Act came into force only in 2005. But even so, it has been 10 years, and we didn't see either these cases are not being litigated or they haven't reached the Supreme Court yet. And our database is limited to the Supreme Court cases. Now, can you go to the next slide? Sorry, can we just go back once? The others category over there, which is a pretty big category, it includes things that are not captured by existing categories, probably because there was only one or two cases regarding each of these. It's as varied things like constructing a police station, a jail, a market yard, or an agricultural market. So a one-time acquisition for one specific thing. So on compensation. Unlike public purpose, compensation expectedly was an issue in the vast majority of the cases, and that also explains why perhaps existing studies have tended to focus on compensation, because that is one of two main issues for which people go to the court. And if we do a decadal analysis, we find that the cases involving compensation challenges peak in the 2000 period, but I mean they start peaking from the 90s onwards. The next question we analyzed here was whether the challenge was to the manner or principle of payment of compensation. Here we use the term manner to include both manner and form of payment of compensation. So this would include instances, so form of compensation would include instances where the government pays compensation, say in the form of government bonds rather than cash. Now, prior to the Constitution, that is before 1950, the government was mandated to pay compensation in cash under the Government of India Act of 1935. But when the Constitution was drafted, Article 31, which was the fundamental right to property clause that Pallav mentioned, there was a provision in Article 31 which essentially replaced the Government of India Act provision, Section 299, but the wording of Article 31 was made more elastic. Compensation could be given, not necessarily paid. So, before the central and state governments took possession of the land. So, compensation could be in any form. It could be cash, but it could also be cash certificates or government bonds. That is some form of deferred compensation. Also, the manner of compensation includes things like compensation paid in installments. So that is another form of deferred compensation. So there are challenges to that as the manner and form of payment of compensation. And then there are challenges to the principle. When we say principle, we mean the basis on which the compensation was computed. For instance, challenges because the government didn't look at, usually the way to compute compensation was to look at of land in the area or to look at the circle rates. So challenges could be based on whether the government didn't look at sale deeds, or when it did, it looked selectively at particular deeds and it didn't look at others, or it followed the circle rates which didn't represent the true market value. All these kinds of challenges would be captured within the term principle of payment of compensation, because you cannot really challenge the quantum of compensation, and that's the claim or the grievance that people are bringing to court. They want more compensation. So because you can't challenge the quantum without impugning the principle, therefore in the vast majority of cases, almost 59%, we have challenges to the principle of compensation. And if we include the 3% where it's manner and principle, as well as the 4.2% where it is principle and other question of law, so we include that 7% as well, it comes to about over 66%. So 2/3 of the cases do involve a challenge to the basis on which the government has calculated compensation. But over 16% of the cases also involve a challenge to the manner of compensation, because that's 13.39 plus if you add the 3% where both manner and principle are being challenged. Which was an interesting finding on ways that the government might reduce conflict simply by changing the manner in which compensation was paid. In other words, if they were to just pay it in cash before possession was taken, at least 16% of these challenges may not be there. Finally, 20% of cases involved other questions of law, where by other questions of law we include challenges not necessarily on the basis on which compensation was calculated to whether it shows the true market value or not, but really claims for increased solatium, or questions as to whether solatium has to be paid for temporary acquisition of land, or whether a subsequent purchaser, because these proceedings take so long, it's possible that the person whose land was notified, it wasn't ever taken possession of for several years. In the meantime, he sold it off to another person, and then that person becomes a party, and then the question is whether the compensation that was paid to that original person, whether the subsequent purchaser can intervene. So there are lots of these other kinds of questions that also come in. About 20% of them involve these other kinds of questions. So I think that in the new law, if the government had actually, dealt with the manner question, like just basically said we'll pay cash, that was one way of eliminating conflict, and other ways would have been perhaps addressing some of these concerns as well. Why are claims for increased solatium coming? Are there, extraordinary circumstances and so on? If they had looked at all of this, it might have been possible to include provisions which would have averted some conflict. Maybe even they have tried to fix some of those things by saying that, land that has not been taken possession of for a period of 5 years, that the acquisition lapses. So perhaps that addresses some of these concerns as well. In the vast majority of these cases, approximately 64%, the High Court increased the compensation payable. But in a significant number, the High Court also reduced the compensation payable. And, we are not able to plot the data for the reference court, the first court of appeal, after the land acquisition officer's decision, simply because a lot of the Supreme Court judgments do not capture the procedural history going all the way back to the trial court. But invariably, the ones that do record this procedural history, we find that often the awards that are given by the trial court are very high, which means that obviously the government is not doing something right, because the amount by which the compensation is already increased at the trial court level is quite high. And then the parties are going all the way up to the High Court and to the Supreme Court. And 64% is of cases, if compensation is being increased, then that's a very high chance. I mean, there is an incentive to litigate for a party to go to the High Court. These other smaller figures, both increased and reduced, both increased and remain same, these refer to bunch petitions of the kind that Pallav spoke about before. In the same group of matters, the court might, involving the same land, either with multiple parties or in bunch petitions, the court might say, okay, this person was given the right compensation, but that person was not given. And that's the small number of cases. If you look at the decadal analysis, the High Court was more likely to increase the compensation starting the 70s and the decades thereafter. But I think what is clear from these graphs is that the incentive to litigate is very high, because whatever principle of computation the government follows, whether it follows sales deeds or it follows circle rates, though the preference, as we see in the cases, is the government tends to prefer circle rates, the reference court is likely to increase the compensation in almost all of the cases, and subsequently the High Court and the Supreme Court. When the cases come up before the Supreme Court, we find again that while the Supreme Court was less likely than the High Court to increase compensation, but even the Supreme Court, in a majority of the cases, over 59%, does increase compensation. So obviously, the ability to litigate to the Supreme Court also speaks to the means of the parties as well as their proximity to the court. But if you have the incentive to litigate, if you have the means to litigate before the Supreme Court, you have an incentive to do so, because you're more likely than not to have increased compensation. Decadally as well, this is interesting because in the 50s we find that the Supreme Court was likely to increase compensation in 100% of the cases. That is not so much the case now. I wonder if it is, one possibility is that, as I said, in the 50s the Supreme Court signals certain things, lays down certain principles. It is the ultimate court of law, and once it settles the law in a certain way until the law becomes unsettled again, the High Courts will follow that. So then it's very possible that once the Supreme Court had laid down the principles, the High Courts were increasing compensation according to those principles. So then the Supreme Court doesn't need to increase it very much more. Next slide. So to conclude on compensation, the fact that the LARR has increased compensation, because that created a huge hue and cry that, this was unsustainable and so on. But actually what we find is that compensation is being increased by the courts anyways. And what the LARR did was a laudable thing, because it actually brought it perhaps more in line with reality. At the same time, when we dig deeper and we did a stratified sample study of about 20% of the cases where the compensation was actually increased by the High Court and the Supreme Court, we find there is a huge variation in the amounts of increase in compensation. The highest increase was 100 times of the original amount that was awarded by the government, and the lowest was only 11% of the original amount. So really, what we are definitely seeing is that the way the government is calculating compensation is not appropriate. And the incentive therefore to litigate is very high. And so interestingly, I mean, it wasn't necessarily what we thought of as we started this work. A lot of our focus was on figuring out how the executive is dealing with compensation, but we realized how, the courts are so much of an important figure in the whole land acquisition story. And I think what our results actually show is how these two institutions have, settled the law in between them, and it has pointers both for the way the judiciary is used by the litigant as well as what the government has to offer, and I'll elaborate on that as we go along. But on the next point, that of procedure, now when we come to the procedure of land acquisition, then there are two levels of challenges here. On the meta level question of whether the land acquisition statute itself was challenged, that's why we have this question of constitutional validity. But just to step back a little, constitutional validity essentially refers to the fact that whenever Parliament or any state legislature makes a law, it must comply with the provisions of the Constitution. And those were the kinds of challenges that Pallav also spoke about under Article 32 and Article 226. So that's the meta level challenge, and then there is a challenge that to the procedure under the law. So the law is valid, but the petitioner claims that the procedure that was used to acquire his or her land was actually an invalid procedure because it didn't comply with the law. So the law has to comply with the Constitution, and the notification procedure has to comply with the law. So with respect to the validity of the statute, we find that it was challenged in only 7.23% of the cases. And if you look at the decadal analysis, we find that almost all of these challenges happened in the first 3 decades. And the largest number is in the 50s, or like about over 40%. Now, again, this can be explained from the fact that most of the land reform laws that were passed in the 50s and 60s were challenged as being constitutionally invalid. Now, since there is a presumption in favor of constitutionality of the statute, it is not surprising that in the vast majority of the cases, over 64%, the High Court, found the statute to be valid. And then the next slide. In the decadal analysis, we find that it is. Can we? Okay, so. In the decadal analysis, we find that it is the 50s which also saw the highest number of challenges. So that's where the High Court also struck down most of the statutes. Now, when we come to the Supreme Court, can we go to the Supreme Court? We find that the Supreme Court is more likely than the High Court to hold a statute to be valid. In almost 69% of the cases, the validity was upheld. On the second level challenge, which is about the notification procedure. Now, petitioners in over 2/3 of the cases challenged the validity of the notification pursuant to which the land was acquired. Now, this represents all kinds of challenges to notification under the 1894 Act. For those of you who are familiar with the procedure, there is a preliminary notification under Section 4, then there is a Section 6 notification. So this includes all kinds of challenges. Sometimes the cases will specify what exactly is being challenged. Sometimes they won't even do that. So next slide. So it is essentially clear that the biggest challenges are coming on compensation and on the procedure of notification under the law. Now, on the question of whether the notification was upheld by the High Court and the Supreme Court, we find were mostly comparable. With both of them upholding the procedure in over 60% of the cases. For the High Court, it is a little over 62%, and for the Supreme Court, it is about 61%. But that also shows that in more than 1/3 of the cases, almost like about 38% of the cases, both the High Court and the Supreme Court are likely to quash the procedure under which the land has been acquired. Now, these cases where the procedure is quashed are those that can be simply described as non-compliance with the law. The law is very clear. It says certain requirements that have to be followed, and the government just does not do them. Also, there are many instances of non-application of mind in the application of the procedures. So these things are very much curable, but they are not curable by legislation. These are indicative either of executive ignorance of the law or apathy, which can only be fixed through administrative awareness of the law and sensitization of the need to follow the rule of law and not do things arbitrarily. But again, that is not something that can be fixed by legislation. Finally, on the urgency clause, this result was, for us, possibly the most astonishing, because conventional wisdom has been that there has been rampant misuse of the urgency clause, but we found that it had been used in only 10% of the cases, a little over 10% of the cases that came up before the Supreme Court. even accounting for 3.4% of the cases where information was not available, because sometimes the cases will not mention if the issue was not if the issue that was litigated before the Supreme Court, and remember, before the Supreme Court, you're only litigating a real question of law or a mixed question of law and fact, and it is possible that urgency was used, but that's not the issue on which the party is litigating. But even then, it's still only about about 14%, and that's a very small number. So it was surprising. Now, in our conversations with government officials, they indicate that at least at present, use of the urgency clause is routine. And if we go to if we but still the overall numbers are very low. So we can't conclude how big a problem this is. Our data is showing it's not a huge issue before the Supreme Court, but we don't know if that's not true of courts lower down the hierarchy. Nevertheless, based on just what we hear anecdotally about the use of the urgency clause by the government, we hear that it's being routinely used. So insofar as the LARR Act tried to curb the use of the urgency clause, it was a laudable provision. Next, we come to the distributional analysis. The first is the time series distribution of judgments. If we can go to the decadal analysis, what we find is that the vast majority of cases, about 70%, have been decided post the 90s. So the first 3 decades only see 30% of the cases, the last 3 decades see 70% of the cases. And the 90s is the highest, with 30% of the cases being in the 90s alone. Now, please remember that this is the time period that when the cases are being decided. And the average life of the case up to the Supreme Court is quite long. So it is very possible that, it is definitely the case that, these cases that have been decided in the 90s have probably originated sometime in the 70s or the 80s. And there could be many reasons for why suddenly the numbers go up in the 90s. One of the reasons could be that the Supreme Court reorganized its docket in the 90s and started bunching matters and disposing them off more expeditiously. And when we look at the yearly analysis of the cases, we find the maximum number of cases, the numbers in red, but very steep numbers in 1995 and 1996, which also goes with this idea of the Supreme Court just becoming more efficient in organizing its docket and deciding these cases. The next two peaks are in the 2000s decade. The next graph. Now, when we look at the state-wise distribution of cases, we find that Uttar Pradesh, it is not surprising that some of the larger states like Uttar Pradesh, Maharashtra, Andhra Pradesh, that they have a very large number of disputes that are coming up before the Supreme Court. But we also see some small states that are there. There's Haryana, there's Punjab, and Delhi is also quite high there. And the reason for that is because a lot of land acquisition happened in Punjab and Haryana for the creation of the state capital of Chandigarh. It was a new capital that was created and a lot of land was acquired. And also parts of Delhi were planned. So, that planned development, which was like very high numbers in terms of the purposes for acquisition, a lot of those cases are coming from there. And also simply because of proximity to the Supreme Court. If your land is being acquired in Delhi, you will go to the Supreme Court. If it's in Chandigarh, you will still go to the Supreme Court, right? But also what made it, why you will see here some states which do not exist anymore, like we have the state of Bombay, is because at various points of time there have been state reorganization. And so this refers to the erstwhile state of Bombay, and we had to code it as such. Now, another explanation for why these cases, why those states are the highest. So we explained Uttar Pradesh, Haryana, Punjab, Andhra Pradesh. Karnataka is interesting. It's not a large state, but, an interesting explanation is that as of now, only Punjab, Haryana, Orissa, Karnataka, and Delhi have substantially computerized their trial courts. And in Karnataka, especially after the Bharuka committee, there was a lot of work done to actually speed up court decisions and so on, which might explain if the cases have been disposed of more expeditiously at the High Court level and at the trial court level, then they might come up before the Supreme Court as well. Next. If you look at central and state statutes, we find that a large number of cases only involved central statutes, 85%. Of which, when we come to the next graph, we'll see the vast majority is the Land Acquisition Act of 1894. But as you would recall, the central statutes can be amended by the states, and a lot of states have actually amended the central statute. So this number also captures those amendments. to the 1894 Act and other central statutes. And I'll to explain this graph to you because the numbers don't add up, but the states, 20% of the cases involved only a state statute, and 6% involved two laws, both a central and a state statute.
So in this graph, basically we are looking at like the two series together, that is the central statutes and the state statutes, and there is certain level of overlapping that we can see. There are like 6% of the cases in which both the statutes, they were central as well as some of the state statutes, they were used simultaneously in a same case. So that's why we are having this overlapping series, and 6.2% is that. And for 0.37%, like we don't have any information, mean there is no information available whether there were the statutes which were central or it was state statutes.
What we find is that a lot of the judgments post the 2000s, they're just like one-page orders, and they don't give a lot of detail about the case, and that's very much a development post the 2000s. The next graph. Okay, so within the central statutes, these are the laws which have been litigated in disputes before the Supreme Court, and 79.8, almost 80% of the cases are under the 1894 Act. A very large number where information is not available, but also, all of these other laws, some of them which were exempted, they were in that list of 13 laws which was exempted by the 2013 Act that were then brought within the purview of the 2013 Act by the ordinance. They are all, there. The Land Acquisition for Mines Act, Telegraphs Act, Railways Act, these were all in that list. Also we find, there are some specific laws that were enacted for dealing with specific urgency issues like Resettlement of Displaced Persons Act of 1948 or the, Displaced Persons Compensation and Rehabilitation Act of 1954. These were, to deal with the situation of partition. So, the question that we sort of come back to when we look at this is that if it is the case, obviously now this data doesn't necessarily show that these laws are not being used at all. What we can only conclude is that they're not being litigated, but I think it would be fair to assume that the Land Acquisition Act of 1894 is being used a lot more than the other laws. Like, we can't say that it's being used 80% of the times. We can only say it has been litigated before the Supreme Court 80% of the times, but we can infer that it is being used much more than any of the other laws. So then the question is, do we need so many laws? I mean, if we are using mostly the 1894 Act, do we need so many laws? On the one hand, some, for instance, the land reform laws or laws like the resettlement of refugee laws, which were dealing with a particular situation, a particular moment in history, those are things that are not envisaged by the 1894 Act, and so it makes sense to have them. But we also see a lot of specialized laws of acquisition, like the Defence of India Act, the Coal Bearing Areas Act. And if we go back to the Law Commission's report in 1958, what it highlighted was that a lot of the times the provisions in these laws are different from the 1894 Act, and that just produces a plethora of legislation and non-uniformity in its application. So, in terms of the rights of the citizen, and that's that's where I guess if you think about it from that point of view, supposing my land is acquired for my same piece of land is acquired for defense purposes. For defense purpose, I might be subject to a different procedure than if my land was acquired to construct a jail or something. Or it could be that my land is acquired for purpose A and somebody else's land is acquired for purpose B, and we are just subject to very different procedures. So in terms of the rights of the citizen, definitely, it is a problem to have different procedures. And what the LARR Act tried to do was to, bring all of this together. Now, there can be other perspectives on this as well, that possibly, the state may not be able to follow the same procedure for every purpose. I can see that there can be rationales for that. But I also think that there is a need for a justification for that, which hasn't sort of come through in the existing literature as we have seen. Or even what the government has put out. So there is definitely a need to look at all of these laws, and perhaps that's the next phase of this project, if we get onto it, is to see what is different about these laws. Are they really being used at all? And perhaps that's something that we can only figure out through interviews with the government and so on. But it would be interesting to see what's happening. Are we only using the 1894 Act? Okay, so there were 263 state laws that were involved in cases before the Supreme Court. Remember, 1369 cases, 263 state laws. And most of these laws were used only once or twice. in cases before the Supreme Court. So again, they've only been litigated once or twice, but again, that means that they're not being used as much, possibly not being used as much as well. And because we couldn't plot 263 laws on this graph, what we did was we bunched the laws belonging to a particular state. And what we find is that Karnataka leads the pack with 9.4% of the cases. And again, it's also, one is having laws and then the other is using them. And what we find is, for instance, the Karnataka Town Planning Act has been used much more than, say, the UP Town Planning Act, or it has been litigated much more than the UP Town Planning Act. So in that sense, that's why some of the numbers are higher. Punjab, again, is not surprising. Uttar Pradesh is the largest state. It was the highest number of cases even overall, and so on. Can we just go back one? Did we have? Yeah, that's fine. Yeah. So in terms of our conclusions, so these were our findings on specific issues, but the larger narrative that has clearly emerged from this study is that perhaps doing two things will make a huge difference in terms of eliminating legal disputes on land acquisition and make the process more efficient and equitable, which we started out as being the goal of our study. The first is we need to implement our procedures prescribed under the law in accordance with the rule of law. And this is a problem not of legislation, but of better administration and better state capacity. On the one hand, the land acquisition officer must be aware of the procedure prescribed now under the 2013 law, since the 1894 law is no longer in force. So, better awareness of the law on the part of the people who are actually executing the law, and also better administration of the law. And finally, there has to be greater transparency and accountability. However, here there are also questions of state capacity, which vary a lot across states. So one thing is knowledge of the law. The second thing is understanding and more sensitization of the fact that you must comply with the procedures, otherwise things are just going to be, hauled up all the way up to the Supreme Court at times. And, what we find based on our review of the literature, and including the book that Mr. Jairam Ramesh and Mohammad Khan wrote on the drafting of this law, that the problems are very deep in terms of the poorly administered land records and poorly maintained land records and inaccurate price reporting and so on. So there are questions about state capacity, and there are questions about state awareness and their determination to follow the rule of law, and those things have to be redressed aside from legislation. The second big problem is please be on that slide. The second big problem is obviously on compensation. I mean, if we are able to get the government to apply the procedure properly, comply with the law, and also apply their mind when filling things out, because sometimes cases are hauled up because some things were not stated properly in the notification, things like that, which will haul up the case for years. And all it needs is perhaps better awareness and better administration of the law. And the second problem is obviously compensation. Obviously, the compensation that is being paid by the government is inaccurate. It's not representative of the value of the land, which is clear from the fact that the reference quote, the first quote, is increasing the compensation hugely, and that the increases are going all the way up to the Supreme Court. But that is a problem, again, that cannot be fixed by land acquisition laws. That is a problem of poorly maintained land records, inaccurate episodic price reporting, especially in the rural areas. And in the scheduled areas, which is another a big area of the country which doesn't even come within this study, just because there aren't marketable titles to land in that area. So how will you assess market value? So in other words, the compensation provisions under the new law haven't really fixed the problem. They might have increased the amount of compensation payable, but if there are no sales deeds in the area, if it is not possible to determine, the land records are not clear, and there is a land mafia which takes advantage of all of this, we're still going to be in the same problem. It's not going to fix that problem. And honestly, even 4 times is just an arbitrary number. As our results have shown, the court is if the cases where there are no sales deeds, or where there has just been an assessment of the land just by the government without any principal cases, they have, the highest level we have cases where compensation was 100 times that of the original value. So it's not going to stem the flow of litigation. And finally, the fact that we have presumptive, not conclusive title over land. So I think these are the things that we need to, Registration Act, the Stamp Duty Act, those laws need fixing. We need perhaps titling law, we need land records modernization, we need all of those things. And unless that changes, nothing is going to stem the flow of litigation under the land acquisition law. So in conclusion, because I started out with the 5 contentious provisions under the new law, I think what are laudable changes are curbing misuse of the urgency clause and recognizing the rights of livelihood losers. We don't know how the second is going to play out. We haven't seen that many cases yet, but we don't know how this is going to play out. I think this is a game-changing move. Let's see how far it goes. The problematic changes, personally, I think the public purpose provision is unnecessary. It is cumbersome. I do not think that it clarified the law in any way, and perhaps it wasn't really needed, because at the end of the day, it lists all these purposes, and and it's just a laundry list, and then at the end of it, it is still inclusive. So it's not as if it is restrictive in that sense. Consent, in my view, is problematic because the very nature of eminent domain is a forcible acquisition. If people are going to consent to their land being taken away, we don't need eminent domain at all. But at the same time, the state does need to acquire land for public purposes. The goal of eminent domain law is to ensure that no private person has to disproportionately pay for the burden of supporting the public good, which is why there is a procedure that has to be followed. There has to be a hearing, there has to be public participation, but you cannot have consent. And which is why we see that in the state amendments, this is what the ordinance had done, because it failed to get it through parliament because of our political situation. Now they're doing it through the states, and the states are most likely to do away with the consent provisions. Social impact assessment is not problematic per se. The social impact assessment is necessary, but obviously what our findings have shown is that even the procedure under the 1894 Act did have a lot of provisions for people to be heard. It's just that the procedure is not being followed. But you're not going to fix the problem of the procedure not being followed by introducing more procedures. The only way to do that is through better administration, better sensitization, and better awareness. Now, obviously, there's an environment impact assessment, which is also a part of the social impact assessment, which is also there under the environmental laws. And so, all these provisions are necessary, are laudable, but at the same time, if they're not going to follow the regular procedure, then the likelihood of following SIA is also low. All it's going to happen is it's going to lead to more litigation, because there are going to be more disputes. So in order to render the process efficient and equitable, if we can fix the government's application of the procedures, if we can find ways of enabling the government to assess compensation fairly, I think we can go a long way in making land acquisition more efficient and equitable. Thank you.